big March 2026 immigration updates are moving fast, and some of them are actually good news. The March 2026 Visa Bulletin shows progress in multiple family-based and employment-based lines, and two separate court developments could change the immediate reality for some immigrants in detention, one blocking certain deportations to third countries and another restoring bond opportunities in some situations. And on top of that, there is a major DHS leadership shakeup being reported, which could affect messaging, priorities, and how quickly guidance gets clarified. By the end of this video, you will know three things. First, how to read the March 2026 Visa Bulletin the right way so you do not accidentally assume you are current when you are not. Second, what the court decisions could mean if you or a loved one is detained, including what they do and do not guarantee. Third, a practical checklist of what to do right now, what to avoid, and what to monitor over the next few weeks. Here is the part most people miss. Good news headlines can still lead to mistakes if you take action based on the wrong chart, the wrong category, or the wrong assumption about whether a court order applies nationwide. So we're going to keep this calm, plain English, and very specific. Let's start with the Visa Bulletin, because this is the update that affects the biggest number of people, and it is where confusion is most expensive. The Visa Bulletin is a monthly Department of State publication that tells you whether a green card number is available for your category and country chargeability. Think of it like a monthly traffic light system for green cards. But there are two different traffic lights, and people mix them up all the time. One is final action dates. That is the chart that tells you when a green card can actually be approved or issued. The second is dates for filing. That chart can sometimes let you file your application earlier, even if final approval is not available yet, but only if you are allowed to use that chart for your situation. This is where people get denied or delayed. They look at the dates for filing chart, think they are current, and then make travel or job decisions as if the green card is guaranteed. It is not. Now, for people inside the United States doing adjustment of status, there is an extra layer. USCIS decides each month whether you should use the final action dates chart or the dates for filing chart for your I for 85 filing. That USCIS decision can change month to month. So for March 2026, the right way to approach the Visa Bulletin is not to ask, did my category move? The right question is, which chart can I use? What is my exact category? What is my country chargeability? And what is my priority date? If one of those is wrong, the conclusion is wrong. Microhook. In about 1 minute, I will tell you the fastest way to check your place without relying on rumor posts or screenshot charts. Now, the brief you provided says the March 2026 Visa Bulletin shows significant progress in several family-based and employment-based categories. Because the exact dates and categories are not listed in the brief, I am not going to invent numbers. But I can still explain what significant progress usually means in practice and who should pay closest attention. When categories move forward, three big groups may benefit. Group 1, people who become eligible to file the I for 85 or submit immigrant visa documents because their priority date is earlier than the relevant chart date. Group 2, people who already filed and now have a chance to see faster approvals because final action dates are now ahead of their priority date. Group 3, families and workers who see a clearer timeline and can plan around travel, renewals, and job changes more safely. But here is the key: movement in the Visa Bulletin does not automatically mean approvals will be immediate. Processing times, background checks, interview backlogs, and document requests still control the day-to-day pace. Myth versus reality moment. Myth: if the Visa Bulletin moves and I am current, my green card is coming in a few weeks. Reality: being current is necessary, but it is not sufficient. It simply means a visa number is available for your category. The agency still has to process your case, and sometimes cases sit because of staffing, security checks, or missing documents. So how do you check your place quickly and safely? Do it in 4 steps. Step 1, confirm your priority date. For family cases, it is usually the filing date on the I-130 receipt or approval notice. For employment-based cases, it is often tied to the perm filing date or I-140 priority date, depending on your category. Step 2, confirm your category. For family, that might be immediate relative, F1, F2A, F2B, F3, or F4. For employment, EB1, EB2, EB3, and so on. Step 3. Confirm your country chargeability, which is usually your country of birth, not your citizenship. Step 4. Look at the March 2026 Visa Bulletin, and then separately check the USCIS monthly page that tells you which chart you can use if you are filing I-485 from inside the US. Small detail, big consequences. If you file based on the wrong chart, you can lose time, money, and sometimes even trigger complications. Now let's talk about who is affected by Visa Bulletin movement versus who is not, because this helps you avoid false hope and avoid unnecessary panic. If you are in a family-based preference category or an employment-based preference category and you are not yet current, any movement can matter. It can change when you can file, when you can get work authorization through a pending I-485, and when you can finally finish the process. If you are an immediate relative of a U.S. citizen, like a spouse, unmarried child under 21, or parent of an adult U.S. citizen, you typically are not limited by the Visa Bulletin in the same way because those categories generally do not have the same numerical caps. But your processing time can still be slow, so you still should care about USCIS workflow updates. If you are doing consular processing abroad, the Visa Bulletin matters, but the steps are slightly different. You watch the final action dates, and you watch for the National Visa Center and the consulate to schedule once you are documentarily qualified and a visa number is available. Edge case that trips people up, cross-chargeability, and derivative family members. Sometimes a spouse can use the other spouse's country of birth for chargeability, which can change the timeline. That is a technical area where you should be careful and verify before you make decisions. Now, let me shift to the court news, because this is where the stakes are immediate for people in ICE custody and their families. According to your brief, a new federal court ruling has blocked deportations to third countries. In plain English, third country deportation means the government tries to remove someone to a country that is not their country of nationality or a country where they have strong ties, sometimes because removing them to their home country is difficult, delayed, or complicated. The concern raised in many of these cases is due process, whether the person gets meaningful notice, a chance to raise fear-based concerns, and a chance to contest removal to a country where they may face danger or where they have no connections. So when you hear blocked deportations to third countries, do not translate that into all deportations are blocked. It usually means some removals to certain third countries, under certain procedures, are paused or restricted while the court reviews the policy or requires additional protections. Here is the part most people miss. Court orders can be narrow or broad, and they can change quickly on appeal. The exact effect depends on what the judge ordered, who is covered, and whether there is an immediate stay from a higher court. Because your brief does not include the court name, jurisdiction, or the exact order language, the safest takeaway is this. If you or a loved one is detained and ICE is attempting to remove them to a country they are not from, this is a major red flag, and you should urgently request clarification in writing and ask the attorney or the detainee advocate to check whether this ruling applies to the case. Now, the second court development you mentioned. Courts restored bond opportunities for immigration detainees. Bond is basically money posted to the court or the government as a guarantee that the person will appear for hearings if released from detention. Not everyone is eligible for bond, and not every detention statute works the same. Some people are in mandatory detention categories, some are in discretionary detention, and some are held under different authorities depending on the stage of their case. So when you hear bond opportunities restored, the realistic meaning is a court may have ruled that certain detainees must get a bond hearing or must get a new bond hearing, or that the government must meet a certain burden at the hearing, depending on the jurisdiction and the class of people covered. Myth versus reality moment. Myth: if bond is restored, everyone gets out. Reality: a bond hearing is an opportunity, not an outcome. The judge can still deny bond, set a high bond, or requires specific conditions. And some people may still be legally ineligible. Here is a simple affected versus not affected breakdown to keep you grounded. More likely affected, detained immigrants who were previously told they could not even ask for bond, especially if a court decision in their region changes that rule. People in prolonged detention with ongoing proceedings, and people whose lawyers can file a motion based on new precedent. Less likely affected, people with final orders who are being removed under separate authorities, people in categories considered mandatory detention under current interpretations, or people in jurisdictions not covered by that specific decision. Again, jurisdiction matters. Two people with identical facts can have different outcomes based on where the detention center is and which federal circuit covers it. Now let's connect this to real life, because viewers often ask, what do I do with this information today? Let's walk through a few example scenarios so you can see how these updates could play out. Example Scenario 1, Visa Bulletin. Maria is in the U.S. on a work visa. Her employer filed an employment-based petition years ago. She has been watching the Visa Bulletin every month, but felt stuck because her priority date was not current. If the March 2026 Visa Bulletin moves her category forward past her priority date and USCIS allows filing using the relevant chart, she may be able to file the I-485 now. That could also allow her to apply for an EAD and advance parole, which can provide job flexibility and travel options later. But if she assumes she can travel immediately, that is where people get burned. Until advance parole is approved, travel can risk the adjustment case depending on status and individual details. The safe move is to wait for the proper document and confirm before booking non-refundable travel. Example Scenario 2, Detention and Third Country Removal. Ahmed is detained. He is told he may be removed to a country he has never lived in. His family hears about a court ruling blocking third country deportations and assumes he is safe. The correct move is more specific. Get the A number, get the removal paperwork, ask for the destination country in writing, and have counsel check whether the order applies and whether a stay of removal is needed. A court ruling can help, but only if it is invoked properly and on time. Example Scenario 3, Bond. Rosa is detained while her immigration case is pending. She was previously told there is no bond. After a court decision restores bond opportunities for some detainees, her attorney files for a bond hearing. At the hearing, the judge looks at factors like community ties, prior compliance, criminal history, if any, and flight risk. Bond is set at an amount the family can potentially pay, and Rosa is released under conditions while her case continues. Notice what changed, not the entire system, but the availability of a procedural step that can change a family's life. Microhook. Next, I am going to give you a do this and avoid this checklist you can save, including what to collect if you are waiting on the Visa Bulletin and what to gather if someone is detained. Before that, one more item from your brief. A political shakeup reported at DHS, including a report that Donald Trump fired DHS Secretary Kristi Noem and nominated Senator Markwayne Mullin. I cannot verify that here, and I am not going to present it as official fact unless you have an official announcement source. So treat this as reported and developing. But here is why it matters in general, regardless of names. DHS leadership changes can lead to shifts in priorities, communication, and the speed at which agencies like USCIS and CBP issue guidance or adjust enforcement emphasis. It does not automatically change the law overnight, but it can change the tone and the operational focus, which is why people feel it quickly. Myth versus reality moment. Myth: a leadership change means all pending cases are redecided. Reality: most individual benefits cases are still decided under existing statutes and regulations, but policy memos, enforcement posture, and resourcing can affect timelines and scrutiny levels. Now, here is your practical checklist. Save this part. If you are a green card applicant watching the March 2026 Visa Bulletin, do this. Confirm your priority date from the official notice. Confirm your category and country chargeability. Check the March 2026 Visa Bulletin on the Department of State website. Check the USCIS monthly chart selection if you are filing I-485. If you may be eligible to file, start assembling documents now, like birth certificates, marriage certificates, certified translations, prior immigration documents, and passport. Pages. Keep copies of every receipt, notice, and approval, and track your medical exam requirements so you do not get delayed by an expired exam if your case is ready to finalize. Avoid this. Do not pay anyone who promises to make your priority date current. Do not file a form based on social media screenshots. Do not assume your friend's category movement applies to you. And do not quit a job or travel internationally based on hope instead of confirmed eligibility and approved travel documents. If you are in removal proceedings or you have a detained loved one, do this. Get the A number and basic case details. Check the EOR automated case information to confirm hearing dates and decisions. Ask for the custody and removal paperwork, including any notice of removal destination. Document any fear of removal to a third country and request a chance to present it. Ask counsel to check whether any recent court order applies in your jurisdiction. And prepare evidence of community ties for bond, like proof of address, family letters, employment history, and a sponsor plan. Avoid this. Do not miss check-ins or hearings. Do not sign documents you do not understand. Do not rely on verbal assurances that removal is not imminent, and do not assume a court ruling applies nationwide without confirmation. Now, what should you watch next after these March 2026 developments? Here are the watch points. 1. For the visa bulletin, watch for either continued forward movement or retrogression. Retrogression is when dates move backward because demand is higher than expected. It can happen quickly, and it can affect strategies like when to file, when to interfile medical exams, and expectations for final approval. 2. Watch USCIS guidance pages because chart selection for filing can change, and USCIS sometimes updates form instructions and evidentiary requirements. 3. For the court rulings, watch appeals and stays. A block on third country deportations can be modified, narrowed, or paused by a higher court. 4. Watch how IC and DHS implement it. Sometimes agencies adjust procedures to comply, like adding notice steps, interviews, or internal review, and that can change what detainees experience on the ground. 5. Watch for additional litigation. When one court recognizes a due process issue, other cases often follow, and that can expand or clarify rights over time. Here is the part most people miss. Even good court decisions can take time to translate into detention center practice. That is why documentation and timely motions matter. If you are directly affected, the practical goal is to preserve options and prevent irreversible actions while the legal landscape shifts. Let's do a calm recap so you know exactly what to take away from this video. 1. The March 2026 Visa Bulletin reportedly shows progress in multiple categories, but you must match it to your exact priority date, category, and country, and you must verify which chart USCIS allows for 85 filings this month. 2. Being current is a major milestone, but it does not guarantee an immediate approval because processing steps still apply. 3. A federal court ruling reportedly blocked certain third country deportations, which could protect some detained immigrants from being removed to countries where they have no ties, but the exact coverage depends on the order and jurisdiction. 4. Courts reportedly restored bond opportunities for some detainees, which can open the door to release while cases continue, but eligibility and outcomes vary. 5. Reported DHS leadership changes can affect priorities and guidance speed, but they do not automatically rewrite immigration law overnight. The bottom line is, this is real movement, and for many families it is meaningful, but the safest approach is precise verification, not panic and not assumptions. If you want, comment with your category type, like family-based or employment-based, and whether you are adjusting status or doing consular processing, and I will tell you the exact official pages you should be checking each month. If this kind of calm, practical immigration update helps you, subscribe and turn on notifications so you do not miss the next Visa Bulletin shift or court update. And as always, take a breath. Double-check the official sources and focus on the next safe step you can control.